COPWATCH, policing the police every single day. And doing what the Charlotte County Sun newspaper and local TV stations won't do every single day.
Supercuts Hair Salon in Naples has been defying the governor's order to stay closed. They said they wanted to help employees who need money to pay their bills.
The salon opened Monday, but today another salon apparently turned them into law enforcement. NBC2's Brianna Fernandez is live outside the Supercuts on Vanderbilt Beach Road.
The Supercuts had their open sign open on just a couple of hours ago. People were coming in and out getting haircuts, but that quickly changed when a hairstylist from another salon noticed what was going on. "We are open" signs were coming from this Supercuts off Vanderbilt Beach Road, many wondering if they were cutting people's hair.
Well, we read an order for what we should be doing, and it says that salons should remain closed. And we saw the word should and thought, well, it didn't say must remain closed, will remain closed, it said should. So we thought of it more as a suggestion.
Verbiage that owners took as an opportunity to open back up on Monday with precautions.
And we did so at 25% capacity. So every decision that is made, the employees were included on that decision.
They claim they got the go-ahead from both CCSO and North Naples Fire Chief.
They both said that as long as we're following the guidelines and are maintaining space, they weren't going to do anything to us. So we're being very careful.
CDC guidelines customers and employees have been following.
Our main priority in this whole thing is to help our employees get money back into their pockets, but we want to keep the community safe.
Just minutes after our interview with the owners, Collier deputies showed up. Turns out a hairstylist from another Supercuts allegedly called the sheriff's office, alerting them to the store being open.
We don't want to do anything to cause problems. We don't want to get anybody in trouble, but we also want to be as safe as possible.
We did reach out to CCSO to see if salon owners would face any consequences or warnings, but have yet to hear back. As for this owner, they won't be opening up tomorrow. For now, live in Naples, Brianna Fernandez, NBC2.
Action that she's defying.
Mitchell Voss says he follows the rules. His salon in Uptown Dallas closed in March, and it stayed closed.
It's been really tough. It's been really frustrating to wait.
We are still open.
Shelley Luther did not wait. The owner of Salon a la Mode has very publicly defied the governor's executive order and then ignored a court order demanding she shut down.
It's hard to watch that. But
Judge Eric Moya yesterday, as a result, found Luther in contempt of court, punishing her with 7 days in jail.
We just thought that was way over the top.
Attorney General Ken Paxton wrote the judge a letter today calling for him to release Luther.
What power does the governor have to shut down businesses if any one business can decide for itself to stay open?
Well, so this wasn't a governor.
Paxton cast blame on local leaders.
How is that not the governor's action that she's defying?
It wasn't the governor that proceeded against her. The governor has put out guidelines, and he was not the one that went to put this woman in jail.
The governor, though, has said cities and counties can enforce it.
It empowers any law enforcement officer in the state of Texas to enforce it.
And that's what the city's lawsuit says it's trying to do. But Luther's received support from the governor himself, who released a statement saying compliance with executive orders during this pandemic is important to ensure public safety. However, surely there are less restrictive means to achieving that goal than jailing a Texas mother. Lieutenant Governor Dan Patrick joined thousands of people in donating to a fundraiser for Luther's legal fees that's now topped $450,000.
If the signal is sent that, well, you're not going to really face any consequence, but
Constitutional attorney David Cole says it's become a matter of law and order.
One case here, one case there, it doesn't seem like that big a deal. But if 10,000 other people around Dallas look at her and say she's just like me and open the next day, you have a big enforcement problem.
Seeing state leaders support someone not following the rules does seem a bit unfair to Voss.
she's now raised, hundreds of thousands of dollars, has a lot of publicity.
But the Attorney General says he's not encouraging anyone to break the rules.
Sending a message to other salon owners?
I said the punishment doesn't fit the action. The punishment is too much. Prison time for this poor woman is not the right remedy.
In Dallas, Andrea Lucia, CBS 11 News.
I'm Dave Champion. I have said consistently
from the very first time that we saw these lockdown orders and business closures, this will eventually be settled by the courts. And we're starting to see that develop now. With that, I want to read you one sentence from Justice Rebecca Bradley of the Wisconsin Supreme Court, asking a question of the attorney for the state of Wisconsin, representing the governor. And here's the question that Rebecca Bradley, a justice on the court, posed to the state's attorney. Quote, "Isn't it the very definition of tyranny for one person to order people to be imprisoned for going to work, among other ordinary lawful activities?" And there's more. From the bench, Justice Bradley also said this: "My question for you is, where in the Constitution did the people of Wisconsin confer authority on a single, unelected cabinet secretary to compel almost 6 million people to stay at home and close their businesses and face imprisonment if they don't comply, with no input from the legislature, without the consent of the people?" These are the kinds of questions that we would expect to hear in a state's Supreme Court from its justices. So what was the answer of the state's attorney? Well, Assistant Attorney General Colin Roth, speaking on behalf of Governor Evers, my mistake, my bad, responded this way to the justices' questions. If you look at the statute, it's in there. Okay, so first of all, that's not an answer. The justice specifically said, where is it in the Constitution? Not where is it in the statute? Because if the people vested any particular party within government other than the legislature to create laws and force people to stay home and force them to shutter their businesses and force them to go bankrupt and force them to go hungry, if the judge is asking, where did the people grant a single member of the executive branch that authority in the Constitution, Mr. Roth failed to answer that. Now, it's not that he mistook the question. He didn't. He's an assistant state's attorney. He knows what the judge was asking. The reality is, because he has no answer, because the people never did confer any such authority via the Constitution upon the government of Wisconsin, he simply dodged the bullet, which is great, by the way, because that wasn't lost on any of the justices sitting up there listening to his answer, that he did not have an answer. Since we're talking about the Wisconsin Supreme Court, I want to talk about the lower courts. It could be any state of the union. The lower courts I have referred to for decades as the courts of status quo. In other words, when the government does this or such, and you go into court to argue that it's improper, it's impermissible, it's unconstitutional, it doesn't apply to you, whatever your argument is at the trial level court, the first entry level. I'm going to file my first petition with the court and get heard there. Unless your argument is incredible and brilliant, even then sometimes, you should not expect to win, because the lower courts, they see their job as upholding whatever the government says. And that's sort of an ethos within the judicial branch. Further, the way the hierarchy of the courts work, and this is understood by all the judges who work within the judicial branch, whether it be in a state or the federal government, is that the Supreme Court does not want the trial courts making decisions on constitutional questions, because you have a lot more judges down there with a lot less experience, right? So the idea is, okay, they're the courts of status quo, which is kind of jacked if you're paying for an attorney, because you go to the court of status quo and you're pretty sure you're going to lose. So then you appeal to the appellate court, and the appellate court, far more often, if your argument is meritorious, it will side with you. If you lose at the appellate court level, then you go to the state's Supreme Court, or if you're in the federal system, you go to the Supreme Court. Either way, then the Supreme Court hears arguments, and that's what we're seeing in Wisconsin. I wanted to bring all that up so that when you see cases at the entry-level trial court where they are upholding these draconian, tyrannical measures, understand their course of status quo. Are they wrong? They are. Are they doing wrong? They are. Should they be punished? They should. There was a judge in Texas that just sentenced a woman to 7 days in jail for opening up her beauty salon because otherwise she wasn't going to have any money to raise her kids. Okay? She wasn't going to have a home. She wasn't going to be able to afford clothing and food, etc. So despite the governor's orders, she went ahead and opened her hair salon. And a judge sentenced her to 7 days in prison for that, a Texas county judge. You know, my immediate thought was, wouldn't it just be too bad if somebody snatched that judge and kept him in a dark cellar for 7 days? That's called retribution. Now, I'm not saying people should do that. I'm not advocating criminal conduct. I'm just saying judges that violate the personal rights of the people who come before their court should be punished one way or another. So when we're looking at this big issue about can the states impose these draconian measures, the best place to look is what the Supreme Court, the United States Supreme Court, has said. And there are 2 cases that I think are relevant. One is Ex parte Milligan, which the decision was in 1866. And it was about the emergency powers of the government. Now, it wasn't a health issue, I want to be clear. But the court sided with the citizen, said it doesn't matter that the government has said this is an emergency because these other factors are in play. And I'm not going to go through the entire decision of Ex parte Milligan. It's rather lengthy. The significant part, for the purpose of this presentation, is the court in its decision wrote a passionate dicta concerning the rights of the American people and that emergencies could not undermine the rights of the citizens, which is clearly what's going on now with this whole COVID-19 thing. The second case that's important is Jacobson v. Massachusetts, and that was decided in 1905. And in that case, the court took a step back from its robust defense of individual rights in Ex parte Milligan. So in Jacobson, the issue was that the state of Massachusetts had imposed a mandatory vaccination policy for all of its citizens concerning smallpox. And Jacobson refused the vaccination and he was fined. So this worked its way all the way up to the United States Supreme Court. And so in 1905, the Supreme Court said that the state of Massachusetts was within its rights to make a vaccine mandatory upon everyone. Now, the cost for not doing so was a fine. What the court may have said, if there was, say, the state wanted to imprison him for 5 years, the court may have come to a different conclusion. I think when we take a look at Milligan and we take a look at Jacobson, and then we take a look at what's going on currently, because we read all this stuff that, the states have broad powers in case of emergency. Okay, so the states do have power in emergencies. There's no dispute about that. The question is, do they have more power? What does more mean? Does that mean more than they ordinarily exercise? Does it mean that suddenly the constraints are off the Constitution and the government can do things it's not authorized in the Constitution to do? Does it mean it can violate our most sacred and inalienable rights? Is that what more power means? Okay, so we need to take a look at that question. By the way, I'm not going to give you an answer. I'm not sitting on a state Supreme Court or the federal Supreme Court. I'm going to give you the framework and you decide. So here's the framework. We've got Milligan and we've got Jacobson. I just want to point out that Jacobson is where the Supreme Court stepped back from Milligan and said, okay, in this circumstance, we're going to say the government can intrude on this person's rights. And the argument of the court, when you read the case, the court argued that sometimes for the greater good, a modest diminution of individual rights in a crisis, which smallpox certainly was, I don't think anybody would argue that, it had a 30% death rate if you were infected, that a small diminution of liberty is permissible. I'm not saying I agree, I'm saying that's what the Supreme Court of the United States said in Jacobson. So we take a look at Milligan, we take a look at Jacobson, and we take a look at what's going on now. What the purpose of that is to highlight the dramatic distinctions between Jacobson, which is the Supreme Court making its strongest statement that states do have the power to diminish and intrude upon a person's individual rights, at least as far as being forced to take a vaccine when there's an epidemic. Okay? So that was the court's most anti-individual rights argument. Okay? Yeah, they can make you take a shot, or, okay, you don't have to take a shot, but you got to pay a fine. Okay, so that was as far as the court went. So what do we have today? We don't have the slight intrusion or diminution, slight of individual liberties. We have massive diminution of rights. We have massive violations of our most sacred, unalienable rights. We have people that are being told, if you step out of your house, except for this, this, or this, we can take you to jail. We can fine you, we can put you in prison, we can do anything we want if you go out of your house, except for these couple reasons we say. We have the court saying, we don't care if you go bankrupt. We don't care if your children starve. We don't care if you're homeless. None of that matters to us because we say you can't work. You can't have a business. You can't run a business. That is obviously worlds away from Jacobson saying, I don't want that vaccine. So the state's saying, okay, here's a $50 fine. Okay? Worlds away. One, we're talking about what the court considered a slight diminution. In the other, this is absolutely massive in scale. It should also be noted that in Jacobson, it was the Massachusetts legislature, the representatives of the people that passed the law saying you have to get vaccinated for smallpox. In all of these cases we're talking about with these massive intrusions into our most sacred unalienable liberties, it is not the legislature doing it. It is one or two jerk-offs in the executive branch. Again, could not be more dramatically different than Jacobson. The question is, will your state take this up through the courts? And of course, the answer to that is, well, if you bring an action, people have to bring an action. Courts cannot act sua sponte of their own volition. Courts, you have to file a petition. When you file a petition, that then vests the court. There are some other factors involved, but for the purpose of this presentation, that then vests the court with jurisdiction to hear the matter. If people remain silent and don't act and don't file lawsuits against this, then the courts are not going to take it up. What I would like to see is tens of thousands of people, hundreds of thousands of people across the country filing suit against these actions, because then we're going to see this all percolate up to probably close to every Supreme Court of every state. From what I've seen, and of course I'm not privy to all the filings in all of the 50 states and all the counties within the 50 states, so I'm just saying as far as what I'm aware of, we have very few suits being filed. Nevertheless, I predict that when this gets to the states' Supreme Courts, and I suspect it'll probably also go to the federal Supreme Court, when it gets there, not all of them, because courts they're jacked up, they're made of frail, faulty human beings like every other man-made enterprise on the planet. But I think the majority of them are going to draw the same distinction I just shared with you now, that the difference between a case like Jacobson and what's going on now is so dramatic that you can't even reference Jacobson. You can't say, well, look, we have the power to do this because of Jacobson. Whoa, what? No, Jacobson didn't even come close to saying that. That's like saying, look at that oak tree. Yeah, well, here's the acorn. Okay, that's the comparison between the level of offense being conducted by the government. So I'm going to speculate that most of the state Supreme Court are going to draw the distinction between something like Jacobson and the mass intrusion on unalienable liberty that's going on now. And I suspect if it reaches the United States Supreme Court, that court will make the very same distinction. And thus, whether it's the state Supreme Court or the federal Supreme Court, will declare these actions unconstitutional. Now, in closing, is there a parallel? Yeah. You remember Katrina down in New Orleans, right? And cops came from all over the country, and they were federalized, and they went into New Orleans, and one of the things they did, which was incredibly egregious, is they confiscated lawfully owned firearms from citizens who were doing nothing more than hanging out in their own home defending themselves. I mean, they weren't even at the window like this. They had a gun in the house in case. And these cops from all over the country, which of course this is, the fact that a cop would do this is just, it conveys a message, number one, and it's disgusting as hell. The cops came in and took their guns away from them. So that generated a lawsuit. Remember I said you got to file the petition in order to get it heard. And a federal court ruled, I don't know, a year and a half later, that the government's action was, and I believe the court's quote was, blatantly unconstitutional. Okay? So there is precedent for something being done in case of emergency, and then when it goes to court, the court says, are you kidding me? No, not even in the same ballpark. So if we had another Katrina type event, maybe a massive earthquake in California, something like that, governments are now on notice. They can't take lawfully owned guns from law-abiding citizens. So if they did that, which would be incredibly egregious, the damages that the citizens could claim would be outrageous monetarily, because it's known, it's established, it's well-settled law. So we haven't had a challenge to the kind of things that are going on now, because these kind of things have never happened before. So I imagine we're going to see the same thing as with the Katrina firearm seizures, that whatever higher courts this eventually gets to, they're going to castigate the state governments. They're going to say, no, this is not even remotely constitutional. All right, I think I've blabbed on enough. Thanks for being here. Have a great day. Bye-bye.
Hey, Charlotte County, this is Charlotte County COPWATCH. I am using any video here under fair use if you have criticism, reporting, teaching, etc. And please donate. I do not make money from YouTube, and there are different ways to donate in the video links. Thanks.